Hello, this is D, and I'm back with another video, and this is my second video of the day. I did a live stream earlier of the FTC's Lina Khan talking to Congress. Now, she had to testify to Congress today, and she was grilled. Now, we're gonna have part of that in today's video. I have it compressed so you guys can see it, but first, we gotta get into the breaking news. Now, yesterday after my video dropped, news broke that the FTC had filed an appeal against Judge Corley's decision to deny its preliminary injunction over Microsoft. And I gotta be honest with you guys, I'm a little bit surprised here that they had the audacity to actually file an appeal. It's crazy. They have no evidence. Their evidence is weak. The judge in her ruling said that the FTC did not prove its case. In fact, to the contrary, that more gamers are going to have access to Call of Duty, and that is going to be better for consumers. She said perhaps not good for Sony, but it will be better for consumers and Call of Duty. So the FTC's whole claim here is that this merger will harm consumers. And the judge in her ruling, which is a ruling based on the facts, based on the case of law, honestly, at this point in time, I think the FTC is wasting the taxpayers' dollars. They don't have any case here. And this came out of nowhere. We were not expecting this. Some people were saying they're going to try to block the deal, but common sense said that they wouldn't because the evidence just did not support them. And this was laid out clearly by the judge. If we look at Tom Warren's post over here, you can see it for yourself. I'm going to read it all. Next to the FTC insists Microsoft's offer is simply insufficient. In so arguing, it relies exclusively on PlayStation CEO Ryan's testimony, finding the fact conclusive of law. The FTC's heavy reliance on Mr. Ryan's testimony is unpersuasive. Sony opposes the merger. Its opposition is understandable. Before the merger, Sony paid Activision for exclusive marketing rights that allowed Sony to market Call of Duty on PlayStation, but restricted Xbox's ability to do the same. After the merger, no such restriction will be in place. Before the merger, a consumer wanting to play Call of Duty console game had to buy a PlayStation or an Xbox. After the merger, consumers can utilize the cloud to play the device of choice. Included, it is intended on the Nintendo Switch. Perhaps bad for Sony, but good for Call of Duty gamers and future gamers. So on what grounds are you going to appeal this? That's what we're going to look into. We're going to get into that a little bit later. Let's look at Tom Warren's right up here. And he says the Federal Trade Commission says it's appealing a recent U.S. federal court order that cleared the way for Microsoft to purchase Activision Blizzard. The FTC has filed a notice that it's appealing Judge Jacqueline Scott Corley's decision, but we won't know the regulator's arguments until the full appeal is submitted to the Ninth Circuit Court of Appeals. Now, that was this morning. So this actually got submitted this morning, and we're going to go over here. We're going to see actually Microsoft's response. Now, this is still from yesterday, so we do have information on what they're actually going after, and be honest with you guys, it's just ridiculous. Now, Microsoft did respond to this, and Lulu from Microsoft said the facts haven't changed. We're confident that the US will remain among the 39 countries where the merger can close. We're looking forward to demonstrating the strength of our case in court again. Now, I hope it doesn't have to go in court again because honestly, the FTC at this point, they're just trying to stall the closing of this merger. It is so evident. We also have a response from Brad Smith, president and vice chair of Microsoft. He said yesterday, the court ruled our acquisition of Activision Blizzard should proceed and we oppose any further delay. Our statement on the FTC's decision to appeal. The district court ruling makes crystal clear that this acquisition is good for both competition and consumers. We're disappointed that the FTC is continuing to pursue what has been an extremely weak case, and we will oppose further efforts to delay the ability to move forward. They have no chance. And at the end of this video, you're going to see that as well. Like I alluded to earlier, Lina Khan was in front of the Congress, and she was actually asked about this. She was asked why she filed an appeal. So we're going to watch this right now, and I'll come back.
But the judge roundly rejected it and said there weren't even serious questions, and now having lost, you're spending even more taxpayer money on an appeal that you're even less likely to win because the appeals court is going to defer to the trial court's findings of fact in this very fact-intensive matter. So why are you spending even more taxpayer resources pursuing this appeal?
So I can say again, this was a staff recommendation. I can say it a general matter. Staff always looks closely at an opinion and looks at whether there are certain errors in law that they believe are worth appealing on. Those are in general the types of determinations that go into whether the FTC ends up appealing.
Okay, so let's look at the errors in law that they presented. We're going to go over to Florian Mueller's page right now. He goes on to say that the FTC has filed an emergency motion for an injunction with Judge Corley, who obviously will deny it. That is the basis for the FTC to then ask the appeal courts for it. It tells us that the FTC's arguments are, and we'll discuss this in a Twitter space later. So we're not going to go through this Twitter space. We're going to go through the documents here. So he goes on to say what they're doing here procedurally is that they're asking Judge Corley to believe her own decision was wrong, and that the basis of that is to now enter an injunction that gives the appeals court more time, not just tomorrow, to rule on the FTC's motion of appeals court. So that clearly is not going to happen. The judge was very precise in her ruling. She's not going to overturn her own ruling. But this is going to give the FTC a chance to go to the Ninth Circuit judge and say, hey, listen, we need this blocked. And they're going to fail there too. And this reeks of desperation, and this reeks of incompetence. Because once again, you're supposed to be protecting the consumers. And all the evidence on this case shows that this is going to benefit consumers. So why are you continuing to try to block this deal? Now it's become political. Now it's all about you wanting to win. It's no longer about the consumers. Now, he goes on to say, I've never seen a judge grant this kind of thing, but the FTC formally has to try it first before the appeals court will decide. The FTC raises a long list of legal arguments. It said before that, just getting the appeals court to decide with the FTC on one or two issues would be enough to change the outcome. It's the runner game with 8 hurdles analogy, basically. Argument A, the court applied the wrong legal standard to the Section 13B proceeding. Argument boils down to the FTC just has to make an initial showing, doesn't really have to prove anything yet for a preliminary injunction. In a deal that has such a huge magnitude to it, you would have to prove it. It does say that. Now, I know they said in the law it says might or may or something like that, and she said might instead of may or vice versa, and that's the reason. But when we look at the evidence, it shows to the contrary. And the judge wrote this in her ruling. That in fact, it doesn't show that it's going to hurt consumers. It shows that it's going to benefit consumers. So it doesn't matter. Your argument was flawed and you actually showed the opposite of what you set out to do. And any judge looking at this is going to be able to see that. Now, he says argument B, the FTC says there was an error to conclude that there was no anti-competitive effects in multi-game library subscription service, despite finding that COD would likely be exclusively offered on Game Pass. Now, once again, Game Pass is a benefit. Game Pass is not going to cost Sony money because they can still have the game on their platform if they sign the contract. Gamers are not forced to go into Game Pass. Game Pass is not an exclusive service. It's just another way of playing your games if you're subscribed to the service. So that is flawed, makes no sense, and it lets you know that the FTC knows nothing about gaming. Argument C, the FTC says, as it already did before the San Francisco hearing, that Microsoft deals with Nvidia, Boosteroid, etc., and offer to Sony should be ignored. Really? So you're arguing that this is going to be anti-competitive, that consumers are not going to benefit from it, but they've made deals with Nvidia, Boosteroid, Sony, Nintendo. They made concessions in the EU. And you think all of this stuff, it doesn't matter? It does matter because it shows intent. And when they've signed contracts to allow these games to be on these platforms, your argument is full void. So which judge is not going to look at that when it's relevant to the case? Makes no sense. Once again, shows you the incompetence. And this incompetence we're going to see in the hearing that Lina Khan had today with the Congress. We're going to get into that a little bit later. I'm really heated up from that one still. Argument D, FTC says that the court incorrectly thought it had not made a partial foreclosure argument in its original motion and that the FTC had not shown a financial incentive for Microsoft to engage in partial foreclosure. Now, looking at the numbers and all the gamers that are on the PlayStation, we know that it doesn't make economical sense to remove it from the PlayStation. They didn't even make a model within Microsoft. This was never even once discussed. Ridiculous. Now we're going to scroll down a little bit. Argument E has multiple parts. The FTC says Judge Corley shouldn't have relied on Microsoft's intent. This involves, among other things, Satya Nadella and Phil Spencer's testimony. What do you mean? Phil Spencer and Satya Nadella said in court under oath that they will not remove this game off of the PlayStation, that it will be there for 10 years. In fact, they offered them a contract that Sony declined. The FTC has lost their mind. This is ridiculous. The FTC says the court improperly assigned the FTC the burden of producing a smoking gun document. Are you serious? You have to prove your case. You are trying to stop a deal from going through, and you waited till the 11th hour to do it. It's ridiculous. In a case like this, which will be the largest game purchase in the industry, or I should say studio developer purchase, whatever you want to call it, in the industry, of course, it should be held to the highest scrutiny. You're going to have to prove your case. You didn't prove your case. The judge said it was to the contrary, that it showed that consumers will actually benefit from this deal going through. But you want the judge and the courts to ignore all the agreements that Microsoft has made with Nvidia, with Nintendo, with Boosteroid, all these companies. Microsoft said they will allow all cloud providers worldwide to have access to these licenses for free. It was only required in the EU, and they said worldwide. Make it make sense. Argument F, the FTC basically argues that there is a conflicting evidence on the anti-competitive effects of the merger. The court should not have resolved the conflict by simply analyzing whether the FTC had met a burden of possibly being able to win. Argument G, balance of equities, multiple parts. Microsoft and ABK should have the burden to point of benefit of economical effects, not the FTC. The court allegedly failed to address the FTC's evidence and arguments regarding immediate harm to innovation. G2, continued competition and harm from sharing of competitively sensitive information between Microsoft and ABK after closing the deal. The FTC thinks it had evidence and strong arguments that future divestiture, I don't know how you say that word. Honestly, this is just ridiculous. You were all following the court case like I was. We had a lot of information here. We pointed to all of the facts of the case. Nothing in this case is how the FTC is saying it in the appeal. This is how you know the FTC is playing dirty. Florian Mueller wrote that a highly disingenuous claim by the FTC. They point to the UK announcement of delaying the appeal as an argument that they can wait in the US. But we all know that the UK CMA wanted to do a deal with Microsoft. Both sides agreed to pause it to negotiate, which of course was initiated by the CMA after they saw the ruling of the FTC in the courts in the US. This is a dirty game. Unbelievable. This will be denied 100%. Now, before I get all riled up and talk about this false appeal, or I should say this appeal that has no merits, we're going to get into the testimony today between Lina Khan and the Congress. And I promise you guys, it gets really spicy. Now, it was about 4 hours and a half. It was a long hearing. So I'll leave it in the description down below so you guys can watch it for yourself. We just have clips of it here. We compressed it because the whole hearing wasn't just about the FTC with Microsoft. They touched on many other things. It's a very interesting watch, and I do encourage that you watch it all because you get to see how incompetent and how unhappy Congress is with the FTC. You also get to see some of the political stuff and how different parties are holding their line when it should be about the consumers and it should be about the truth. But right now, we're just going to get into her testimony today and more or less what they talked about regarding Microsoft.
We got a great court decision last week who talked about this, how pervasive this effort was, and a preliminary injunction from that federal court in the Western District of Louisiana. Just this morning, though, in a filing in federal court, we have learned that the situation is actually even worse than we could have imagined. This wasn't harassment, it was a shakedown. The FTC, as is common practice pursuant to the consent order, required Twitter to hire an independent assessor whose legal obligation is to be truly independent and objective, not for one party or another. Well, it turns out objectivity was not what the Federal Trade Commission was interested in here. Here's what the filing said about Ernst & Young, the independent assessor hired in this matter. Quote, the FTC was so adamant with Ernst & Young conveying that this is absolutely what you will do, and this is going to occur, and you'll produce a report at the end of the day that would be negative about Twitter, that senior Ernst & Young leaders feared that if Ernst & Young resigned as the independent assessor, the FTC would take exception to their withdrawal and create other challenges for Ernst & Young over time. This is not conjecture from Twitter. This is from sworn testimony of the independent assessor in the deposition itself, taken just last month. This is outrageous. This is unacceptable. And it's the kind of behavior that occurs in banana republics, not in the United States of America. And so it's no wonder Chair Khan has no interest in providing information to the people's representatives in the Congress, to the people on this committee when we ask for it. To date, the FTC has not fully complied with a single request for documents from this committee. And because of her mismanagement, not even her own staff is impressed with Chairman Khan's leadership. In 2020, the last year under the Trump administration, 87% of FTC employees agreed that senior leaders maintain high standards. Under Chair Khan, that figure fell to 53% in 2021, has declined even further to 49% in 2022. In 2020, 83% of surveyed FTC employees agreed that they have a high level of respect for the FTC senior leaders. Again, under the chairman, that figure plummeted to 49%, and then appears to have misled Congress about taking that advice. We have a lot of questions today to get through. I affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief. So help you God. Let the record reflect the witness has answered in the affirmative. Thank you. And please know that your written testimony, you've seen this before. You've sat back behind the chairman before, or the former chairman before. So that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. We'll be a little lax with that if you need a few extra. Chair Khan, you may begin, and then we'll move to questions.
Chairman Jordan, Ranking Member Nadler, and members of the committee, thank you for inviting me to testify today. I'm glad to join you to discuss the FTC's work to promote fair competition and protect Americans from unfair and deceptive practices. It's a particular honor to appear before this committee, where I had the great privilege of serving during its historic bipartisan investigation into digital markets and the power of large technology platforms. As this committee knows well, there has long been a battle in this country between monopoly power and America's democratic institutions. Congress created the FTC in 1914 against the backdrop of an industrial revolution that had delivered significant technological advances, but also enabled intense consolidation. Given deep national unease about the unchecked power that these monopolists could wield, lawmakers tasked the FTC with preventing unfair methods of competition and scrutinizing business practices through regular data collection and continuously building expertise.
You're failing in that, you're going to fail. You then took on Microsoft. Microsoft's a big company. Everybody up here seems to want to beat on anyone that has over $1 trillion market cap. And when you served on the committee, you were big on, if you were over $1 trillion, we need to break you up or stop you. However, that merger that you lost the other day is one in which a protected market that Sony enjoys in Japan, a company that is already larger, needs competition. The reality is, we are a global market, and you are thinking only of who you want to go after for some reason. And I cannot find your logic, and I believe that it begins at the top. When you blamed your staff and said staff decisions, shame on you. The fact is, you run this organization, and its left turn came when you took over, not with the staff that many of whom would have already been there.
According to your Senate questionnaire, you held yourself out as counsel for the Democrats on this very committee. You used this title, but you are not licensed to practice law. Counsel is a term reserved for lawyers, licensed lawyers. And in Wyoming, a person who in any manner holds themselves as competent to practice law without a license to do so is guilty of unauthorized practice of law. I believe the law in the District of Columbia, where you held yourself out, is similar. Do you believe it is appropriate for non-lawyers to claim the title of counsel?
Congressman, when I had the honor to work for this committee, I complied with all of the document requests that the HR folks requested, including documentation about the fact
When I checked your registration status this morning, I learned that you are not in good standing with the New York Bar. Your license is listed as delinquent, which means you have failed to file your biennial registrations, and it means that you have not been paying your bar dues, completing your continuing legal education, and maintaining your law license. I believe it's shown on the screen. It also means you're subject to referral for disciplinary action. I find this situation to be stunning and a reflection on your ethics. With that, I yield back.
Well, due to the rank partisanship that's come up in your agency, the fact that you all are ignoring congressional requests for information and the wastefulness that we've seen, I know that the Appropriations Committee is marking up your budget as we speak, and they are seeking a 25% reduction in funding for the FTC today. Actually, the Appropriations Committee is going to be passing that government funding bill. So actions have consequences, Madam Chair, and you're about to see what consequences your actions have had. I yield back.
Gentleman yields back.
Determinations
But
about
are you
whether
bringing
to
cases
appeal?
that you expect to lose?
Could you repeat
Are
that?
you bringing cases that you expect to lose?
Absolutely not.
Okay, well, your track record seems to suggest otherwise. Let's look more closely at the activision decision, though. The court first noted that in an attempt to lower your burden, you essentially made up case law. You couldn't find anything actually that's the courts have provided in terms of precedent, so you cited to your own FTC decision as precedent. But irrespective of the legal standard, the court, you probably wouldn't have won under any standard because the court said this, that the FTC has not raised serious questions regarding whether the proposed merger is likely to substantially lessen competition, not raised serious questions. The court also rejected not only rejected your assertion of a likely anti-competitive effect, but found just the opposite, that the record evidence points to more consumer access. So why should Americans have faith in your judgment when this Biden-appointed judge says you are so far off the mark?
Congressman, this matter is still pending before the FTC in administrative adjudication, so I'm just going to be limited in what I can say about the merits. Our complaint lays out the staff's view of what this merger would result in and why that would be a law violation.
But the judge roundly rejected it and said there weren't even serious questions, and now having lost, you're spending even more taxpayer money on an appeal that you're even less likely to win because the appeals court is going to defer to the trial court's findings of fact in this very fact-intensive matter. So why are you spending even more taxpayer resources pursuing this appeal?
So I can say again, this was a staff recommendation. I can say at a general matter, staff always looks closely at an opinion and looks at whether there are certain errors in law that they believe are worth appealing on. Those are in general the types of determinations that go into whether the FTC ends up appealing.
Gentleman.
Now you guys can see it for yourself. She danced around all of the hard-hitting questions. And I'll give you a spoiler. The other side wasn't asking her anything about Microsoft. They didn't ask her one question about the Microsoft merger or the appeal. Other things that I wasn't able to show in this video is that their approval rating dropped by over 50% since Lina Khan has taken over at the FTC. She is incompetent. She is wasting the taxpayers' dollars. Her appeal will fail because it's based on the facts, and the facts are just not supported by the FTC because the FTC didn't have any facts. In fact, they had a lack of evidence. In fact, they proved the opposite. It was to the contrary. This deal will benefit the consumers. And now it's a race against the clock. The FTC is wrong and strong. Congress is on them. And I got to be honest with you guys, I'm surprised that they filed this. I didn't think they would file this when they had to face Congress today and know that they would be questioned about this stuff. And they were questioned about some hard stuff. I left out the stuff that didn't pertain to gaming. Like I said, you guys can watch that in the full coverage of it. I'll leave it in the link down below. But on the gaming stuff, she was grilled on it and she couldn't come out with a response. And now it's a race against the clock. First, they're going to Judge Corey to get an appeal. Of course, this is going to be denied, but this will give them a reason to go to the Ninth Circuit judge and file an emergency stay or an emergency appeal or block or whatever the hell they're going to do. It's not going to work. I'm going to tell you a few reasons why it's not going to work. Number one, I got to say, Microsoft is moving at the speed of light right now. Yesterday, we found out that the trade desk is there to replace Activision Blizzard in the NASDAQ 100 index. So come Monday, Activision Blizzard will no longer be on the NASDAQ 100. So Microsoft, they already transferred over the money. They're ready to finalize this deal. And the FTC at the last minute is racing to try and stop this deal. When they know it's not about consumers. The evidence doesn't show that it's about consumers. Now it's about the FTC. Now it's about them getting a W. In the last years since they've taken over, all of their court appearances or all of their cases that they brought forward, they've lost them. And they are desperately trying to show face here, but the facts just don't support them. And it once again shows the incompetence of the FTC. To add more salt to the FTC's wounds, Turkey has unconditionally approved Microsoft's proposed Activision Blizzard acquisition. This is another country in a growing list of countries that have approved this deal. It's unbelievable how incompetent the FTC is. Honestly, when I just sit here and just think about the FTC, my head just hurts. I don't understand why they just didn't do a better background check on Sony. Like I've said many times before, they are the #1 offender when it comes to exclusive titles, when it comes to putting up walls against gamers that you have to go to their platform, exclusive content via third-party deals. They lie about everything. We're finding out today, this just kind of came across my timeline, so I'm just gonna splice it in here. But we found out that Ratchet & Clank is possible without an SSD, when Sony clearly told us that this is only possible on the PlayStation 5 because of the SSD. So Sony lies constantly. And if the FTC did their due diligence, they would see this. They would see that all of Sony's complaints were not valid, and we wouldn't be in this situation. But like I've said, we know this now. The FTC is aware of all of this. The judge's ruling was very clear on this, that they had no evidence, that in fact it was to the contrary, that consumers will benefit more from this. So now you want the courts to stop this from going through when it's already being prepared to go through, when you lost in court, when you lost on the merits of the case, or I should say the facts of the case. You lost. You didn't prove your case. You didn't even come close to proving your case, and you tried multiple fronts. Take your L and go home. Go after someone that is legitimate. Go after Sony and their anti-competitive practices. Go after Sony for roping you into this in the first place. Because Sony was the biggest proponent against this deal. And guess what? They are the market leader. And guess what? They have the most exclusives. Bunny had the most games. They are Microsoft's #1 competitor. And you listen to them. During Congress today, Sony was referred to as if they were small. The FTC is protecting Sony. You're doing a good job. Sony is huge. They're not small in the gaming department, in the gaming market. They should have done their research so they would have known this instead of getting the ass whipping that they got during the hearing. Anyways, I think that's pretty much it. We're going to wrap it up here. I'll be honest with you guys. I don't understand what the FTC is thinking. It was shown their incompetence today. She doesn't have her law license. She's not respecting the rule of law. In fact, making up her own reasons on why the judge should have found things her way. She's wasting the taxpayers' dollars in going after this appeal. We also found out that the approval rating of the FTC has gone down tremendously. Today, we found out that their funding was decreased by, I believe, down to 33% or something like that. I'll have it up on the screen. So that actually was passed today. They have less funding now. So this is an actual effect from her actions. Now, there was so much discussed in the hearing today. And like I said, I did a live stream. It was about 4 hours and a half. I'm going to link it in the description down below. You can watch it in its entirety. And I did give a little bit of commentary on that video. Not too much. During the breaks, I did speak a little bit more. So there is some juicy stuff in there. There's some other areas that they talked about. It's not really geared towards gaming, so that's why I omitted it from this video. But like I said, if you want to watch it, it's there for you to watch in its entirety. Anyways, I wonder what you guys think about all of this. Personally, I think today's Congress hearing proved that the FTC is incompetent. Lina Khan didn't want to answer a lot of questions, and they grilled her. Anybody else telling you that she didn't get grilled today, they need to watch the hearing in its entirety. This was not a good look for the FTC. We know that the appeal is filed now. They're in the 11th hour. They're trying hard to get this deal to be at least paused. They're being disingenuous, saying that the CMA is waiting as they work out a deal with Microsoft so the FTC can wait. Once again, showing that the FTC and CMA are working together. So the CMA tells Microsoft they want to negotiate. So Microsoft says, okay, we're going to hold off on the appeal now while we negotiate. The FTC files their appeal and says the CMA has the Microsoft deal on hold as they negotiate. So there's no rush. So we can hold on and we can pursue this case. It's ridiculous. And honestly, the FTC doesn't have a leg to stand on. I said this from the beginning. The evidence just does not support what they're saying. It was read out by Congress. It was read out by the judge. She is a Democratic judge. A Republican judge is definitely not going to overrule her because they are not happy with the FTC. Another Democratic judge is not going to overrule Judge Curley because the facts just don't support the FTC's claims. So the testing 1 2 3 testing 1 2 3. The bottom line is that the FTC is wrong and strong. They're wasting the taxpayers' dollars. They're incompetent. I don't believe that this appeal will go through. I think that Microsoft is going to be wrapping this up as we speak right now on the Nasdaq 100. Activision is being removed in preparation for Monday's announcement that Microsoft has completed this deal. So we're in the home stretch. Of course, I'm going to keep you guys as up to date as possible. Like I usually say, please like, share, subscribe to the channel. Let me know what you guys think about all of this in the comment section down below, and I'll see you guys on the next one.